Jurisprudence, introductions, the scope of jurisprudence, accessibility of jurisprudential concepts, the key legal frameworks and theories, case law and legal provisions, the relevance of jurisprudence, descriptive, normative, and critical legal theory. The case of the Spillation explores why jurisprudence and the point of legal theory. Jurisprudence, the philosophical study of law, is a complex discipline that explores the fundamental nature and purpose of law. This presentation is to elucidate the key concepts, the debates, the theories within jurisprudence for the students and the general public. We shall have a look at the essence of the law, its relationship with justice and morality, and how various legal frameworks shape our understanding of the legal system. At its core, jurisprudence seeks to answer several pivotal questions, such as what is law? Is law merely a set of rules, or does it encompass more? What is the relationship between law, justice, and morality? How do concepts such as democracy, legal positivisms, and legal theory influence our comprehensions of law? These questions form the bedrock of jurisprudential inquiry and guide our explorations of legal theory. Jurisprudence is a vast field that encompasses things such as the definitions and functions of law in society, the connections between law, justice, and morality, legal reasoning and statutory interpretations, the role of judicial system, the relationship between law and other disciplines, such as economics, politics, and anthropology. While jurisprudence can be daunting due to its technical language and seemingly arcane debates, however, jurisprudence is it is possible to make the idea of jurisprudence accessible and engaging. We shall see the essential questions of legal theory and their relevance to the practical applications of law without oversimplifying those concepts. Jurisprudence boasts a rich and voluminous literature, so the reference should be based on textbooks, monograph, journal articles. Legal positivism is a dominant theory in jurisprudence. It asserts that law and morality are separate. The key proponents of this include John Austin's, which developed the common theory of law, H.L.A. Hart, which refined legal positivisms with his concept of rule of recognitions, Joseph Ross, which provides or explain the advanced exclusive legal positivism. There is the separation thesis. Law and morality are conceptually distinct, and there's a social fact thesis. Legal validity is determined by social facts, not moral considerations. While natural law theory contends that there is an inherent connections between law and morality, notable theories of natural law, such as Thomas Aquinas, which argued for the existence of eternal, divine, natural, and human law, John Finnis, which developed a modern natural law theory based on practical reasonableness. The moral test is a law that is gravely unjust is not valid law. Another concept, such as the common good principle, law should serve the common good of the community. Legal realism Legal realism focuses on how the law operates in practice rather than abstract rules. The key figures include Oliver Wendell Holmes, famously stated that the life of the law has not been logic, it has been experience. Carl Llewellyn emphasized the importance of context in legal decision making, and other concepts such as the prediction theory, which says that the law is a prediction of what courts will do. And the other one is the indeterminacy thesis, which means legal rules alone do not determine the outcome of cases. Critical legal studies, CLS challenges traditional legal theories and examines the law's role in maintaining social hierarchies. The scholars include Roberto Anger, which critique liberal legal theory, Duncan Kennedy, which analyze the political nature of legal educations. Legal reasoning is inherently indeterminate, so the rights discourse can obscure the underlying power relations. Feminist legal theory Feminist legal theory examines how gender influences the development and applications of law. The theories such as Catherine McKinnon developed theories on sexual harassment and pornography. Carol Gilligan proposed an ethic of care in moral reasonings. Some of the concepts, such as equality principle, which means that the laws should promote substantive gender equality. The anti-subordinations principle, which means that the laws should not perpetuate women's subordination. Throughout, there is a several landmark cases and legal provisions which are mentions that can illustrate key concepts of jurisprudence, such as R versus R. This case overturned the marital rate exemptions in English law. It demonstrates the evolutions of legal principles in response to changing social norms. Donahue versus Stevenson's. This case established the modern concept of negligence in English law, illustrating the development of common law principles. Brown versus Board of Education in the United States, in which the US Supreme Court case overturned the separate but equal doctrine, highlighting the law's role in addressing social injustice. Roe versus Wade, United States. This case established a constitutional right to abortions in the US, which demonstrate the intersections of law, morality, and individual rights. It is to be noted that this case has been overturned. Human Rights Act 1998 in the United Kingdom. This act incorporates the European Conventions on Human Rights into United Kingdom domestic law. This illustrates the interactions between national and international legal frameworks. Equality Act 2010, United Kingdom. This act consolidates various anti-discrimination laws, showcasing the law's role in promoting equality and social justice. Jurisprudence is not merely an academic exercise. It has profound implications for the practical applications of law and the pursuit of justice. By engaging with jurisprudential concepts, we can, among others, develop a deeper understanding of legal reasonings and decision making, critically analyze the strengths and weaknesses of legal systems, explore the relationships between law and social justice, and also consider how law might be reformed to better serve society. Descriptive legal theory. It aims to explain the law as it is, why it exists in its current form, and the consequences it produces. This type of theory can be broken down into three subcategories. The first is doctrinal descriptive theory. This approach focuses on explaining specific legal doctrines. For example, it might analyze the principles underlying freedom of expressions by examining court decisions that delineate the boundaries of free speech. It seeks to uncover the theoretical foundations that justify these legal doctrines. Explanatory descriptive theory. This subcategory attempts to explain why the law is structured in a particular way. For instance, Marx's legal theory provides an explanatory framework by suggesting that laws reflect the interests of the ruling class. It delves into the socio-economic and political factors that shape legal norms. And finally, consequential descriptive theory. This approach is concerned with the outcomes of legal rules. For example, economic analysts of law might use their tools to predict the behavioral effects of a strict liability regime on manufacturers. It assesses the practical implications of legal rules on society. Normative legal theory, it concerned with what the law ought to be. It is inherently value laden and often intertwined with moral and political theories. Normative theories can be divided into two main types. The first is ideal normative theory. This type of theory envisions the best possible legal system. Assuming no practical constraints, it explores what legal rules would create the most just and effective legal system if they could be implemented without any limitations. And the second one is non-ideal normative theory. This approach takes into account the practical constraints and limitations that exist in the real world. It evaluates what legal rules should be adopted given these constraints, such as enforcement difficulties or political feasibility. Normative theories often rely on descriptive theories to support their arguments. For example, utilitarianism in normative theory, it requires a descriptive account of the consequences of a specific rule to determine whether it maximizes overall happiness. The critical legal theory challenges the foundational assumptions of jurisprudence. It argues that law is not a neutral or objective body of rules, but is deeply intertwined with politics and power dynamics. The key points of critical legal theory include such as interdeterminacy of law. Critical theorists argue that law is not a coherent and determinate set of rules. Instead, it is uncertain and open to multiple interpretations. Law as a tool of power. Law is seen as a mechanism that reflects and reinforces the interests of powerful groups in society. It is not an autonomous discipline, but is inseparable from political and economic power structures. Critique of objectivity. Critical legal theories question the notions that law can be objective and neutral. They argue that legal decisions are influenced by biases and perspectives of those in power. Lon Fuller's hypothetical case, the case of the Spelunchians explorers, is a seminal work in legal theory that illustrates various legal philosophies through a fictional scenario. The case involves four explorers trapped in a cave who decide to kill and eat one of the number to survive. The case is presented through five judicial opinions, each reflecting a different legal philosophy. The summary of the case is these four members of this Spelunchian society are trapped in an underground cave. After 20 days without rescue, they decide that the only way to survive is to kill and eat one of their number. Roger Wetmore proposes casting dice to determine who should be sacrificed or killed. After initially agreeing, Wetmore withdraws, but the others proceed, and Wetmore is killed and eaten. The survivors are eventually rescued and charged with murder. Justice stating indecisive and conflicted. Tating struggled with the moral implications of the case. He ultimately withdraws from the decisions, unable to reconcile his legal reasoning with his moral beliefs. Justice Foster adopts a purposive approach, arguing that the purpose of the law is to preserve life. He believes that the statute should not apply in these extraordinary situations and that the defendants should be acquitted. Justice Handy, a realist who considers practical politics and public opinion. He argues that common sense and the will of the people should guide judicial decisions, and he would acquit the defendants based on these considerations. Chief Justice Trupani, a formalist who adheres strictly to the letter of the law, he believes that the clear language of the statute mandates a convictions for murder, regardless of the circumstances. Justice Keene, an unyielding positivist who also focuses on the plain meaning of the law. He argues that personal feelings and moral considerations should not influence judicial decisions. Some of these key legal philosophies can be illustrated as follows. Formalism. So, what is formalism? Represented by Chief Justice Trupani. Formalism emphasizes strict adherence to legal texts and rules without considering broader social or moral implications. Legal positivism. Justice Keene's opinion reflects legal positivism, which holds that law is a set of rules and commands that should be followed as written, irrespective of moral considerations. Natural law. Justice Forster's approach aligns with natural law theory, which posits that law should be based on moral principles and the inherent purpose of preserving human life. Legal realisms, Justice Handy's opinion embodies legal realisms, which argues that law should be shaped by practical considerations, public opinion, and the realities of human behavior. Judicial indecisions, such as Justice Dating's withdrawals, highlights the challenges judges face when legal reasoning conflicts with personal moral beliefs. The broader implications of this case serves as a vehicle for exploring fundamental questions in legal theory, such as the relationship between law and morality. The case illustrates the tensions between legal rules and moral principles and how different judges navigate this conflict. The nature of judicial decision making, it highlights the diverse approaches judges can take, from strict adherence to legal text to considering broader social and moral contexts. The purpose of law. The case prompts reflections on whether law should be rigid and ruled down or flexible and responsive to extraordinary circumstances. Public opinion and law. Justice Handy's opinion raises questions about the role of public opinion in shaping legal decisions and legitimacy of judicial authority. Why jurisprudence? As already mentioned, jurisprudence has general frontiers. It accommodates copious subjects of intellectual inquiry. And the magnitude of this expanding discipline explains in part why some of us feel discomfort about this topic. It aims to identify and elucidate several of the major preoccupations of legal theory. They are not substitute for the reading of primary sources. No society can be properly be understood or explained without a coherent conception of its law and legal doctrine. The social, moral, and cultural foundations of the law and the theories which inform and account for them are no less important than the law's black letter. Among many topics within legal theory's substantial uh, presence is that of the definition of law as well as legal concepts. It stands to reason that before we begin to explore the nature of law, we need to clarify what it is we mean by this elusive concept. If someone said that time is an incredibly important and fundamental feature of the universe and human life, and therefore it is very important that we define it, yet jurisprudence and the law itself is does require a lot of definitions. The world faces significant challenges with 40% of the populations living in poverty. Developing countries struggle with hunger, lack of safe drinking water, and high illiteracy rates. Legal theory aims to address these issues by exploring the relationship between law and justice. At the same time, legal theory must confront the limitations and constraints of the law. The law is not an autonomous realm untouched by political, economic, and social forces. Indeed, the law is often used to entrench existing power structures and to resist progressive change. Critical legal theories have powerfully argued that the law is inherently political and that it reflects the interests of dominant social and economic groups. Nonetheless, the law remains a crucial political struggle. The law can be a powerful tool for social transformations, even if it means by which the status quo is maintained. By understanding the theoretical underpinnings of legal system, we can better evaluate its strengths and weaknesses and work to reform it in the service of a more just and equitable society. Ultimately, the point of legal theory is to shed light on the complex relationship between law, power, and justice. It is a vital intellectual endeavor that can help us to navigate the challenges of our time and to envision a better future.